If you haven't watched Beau's previous video about trust and homestead, it's available now. Special episode with Atty Taylor Morris. Watch now.
I'm an estate planning and probate attorney with Morris Estate Planning Attorneys, and we practice solely in the areas of estate planning and probate law.
Hey everyone, I'm here with my good friend Taylor Morris, estate planning extraordinaire. He's going to tell us some different ways that we can hold title when you're going into escrow. You're going to get this sheet and they're going to ask you how you want to hold your home, and you kind of want to be prepared before you hit that table. So Taylor's going to go ahead and explain the benefits of each type and how he would hold his title.
Yeah, I appreciate it, Beau. A very good topic. Probably something that for a lot of clients is the most important thing, because a lot of times the home is the primary asset that people have. Mm-hmm. And so the way that they take title can have a big impact on what happens with their home if somebody dies.
Okay.
If they die or even a spouse dies. So just a quick example, you would think that if you own a home with a spouse, you're both on the deed, that if one of you dies, you just own the home as the surviving spouse automatically. And a lot of times that can happen, a lot of times it doesn't happen.
Okay.
I've had many instances, even with a married couple, where they're both on the deed, one spouse dies, we got to go to probate to settle that half of that home and transfer the ownership because the deed wasn't properly, it didn't have the right language on it and recorded the right way.
And I mean, honestly, these people, when you go to the escrow company, you have a notary there, they're going to just say, yeah, that's what most people do. They're not attorneys. They don't have the ability to tell you what is best for your situation. So you hope you have the notary that's done this more than once or twice and just didn't hear from down the hall that always, check the first box and you're good to go.
It's a good point. Title companies can advise you. They always say they're not attorneys. They're not going to tell you what to do. It's important that you have good people like Beau that can point you in the right direction, at least tell you the things that you should think about. Have a good attorney that can explain what these things mean before you close. But here are some of the common vesting language that you'll see on a home that you can choose when you close on a home.
Okay.
And so one is what I would call tenancy in common. 2 or more people, and it doesn't have extra wording like a joint tenancy. Mm-hmm. Or a trust,
gotcha.
For example.
Yep.
Or in Nevada, like community property with rights of survivorship. So tenancy in common means 2 or more people own the property, and it could say a lot of different things. It could just have their names as people. It could say their names as friends. It could say their names as individuals. It doesn't matter what comes after it. But if they're named and it doesn't say joint tenants or community property between like a spouse, mm-hmm. then it's a tenancy in common deed. And that means if one of those owners dies, then that interest that that person owned in the home does not transfer automatically to the other owners that are on the deed.
Okay.
It means that it goes to their estates.
They're surviving.
So their estate means if they have like a last will and testament, their will is going to say where that interest in that home is
that 50% interest in that home should go. Okay.
Correct. And if they don't have a will, then Nevada's laws will say what happens to their estate, and in turn what happens to their interest in that home.
And that's the probate process, right?
That's the probate process. So anytime you see a deed that's owned as a tenancy in common and one tenant dies, that means they're going through probate to some extent.
So, in your opinion, unless you have those documents on the back end, it's going to lead to more issues if something were to happen with that second party.
Yeah, even more so. And so even between spouses, let's say you're married and you own the property jointly as spouses, but it's a tenancy in common. If one spouse dies, we still have to probate the half of the deceased spouse for it to go to the surviving spouse if the language isn't right. That's what tenancy in common means. So even with the spouse, if it's a tenancy in common, it's not going to be an automatic transfer, which can create a lot of heartache and headache for the surviving spouse.
All right, so what about joint tenancy? How's that?
Yeah, so joint tenancy, if you're going to own it between, more than one person, that's the most common vesting that I see.
Okay.
Usually. Between a spouse, it's probably the most common, unless you have a trust. If you own a home between other family members or friends or partners, and it's not part of like a business or a trust, it's usually going to say joint tenancy.
Okay.
And a lot of times that's the right way to do it in those situations, but sometimes it's not.
Yeah, so, if it's a business dealing and you want your assets going to your family, not to your business partner, that's probably not your best option there, I would assume.
Correct. So if the person you own it with, if you want that person to have it 100% and if you die, then it should be a joint tenancy.
Okay.
It's going to go to that surviving owner or the surviving owners equally, if there's more than 2. It's kind of automatically, once they record a document when the person has died where they're saying that the interest is now being transferred over. So you still have to record
no probate though. It doesn't have to go to the courts, doesn't have to go through that process. Just some filing of some documents.
That's correct. So after the recording's done, the ownership transfers, you avoid the probate process. So that's the advantage over a tenancy in common, is you avoid the probate. But like I said, sometimes joint tenancy might not be correct if you don't want those other parties to have the ownership of that property.
Which makes sense. Or it's definitely, I could probably name a few just off the top of my head of situations where you don't want that happening.
Correct.
And then obviously you can own it in a trust, but you still have to file it, correct? A trust isn't an option on the closing documents, right?
Yeah, so on the closing documents, unless you've informed the lender and the title company that you're going to own it in your trust name, which you can do. A lot of times when you get to the end, it's going to say tenancy in common, joint tenancy, community property. The trust might not be on there unless you've already provided them the documentation and they have it with them.
Oh, and they're ready to go.
Yeah, so unless you have a trust already that exists and that you've given the documentation to your lender and to the title company, it's probably not going to be an option at the end.
Okay.
But it could be, and if they have a trust that exists, then they can, close it in the name of the trust, and the trust will hold title to the deed, which, in my mind, is the best option, especially if you have a trust.
Yeah.
But that's not one of the more common investing options if you don't have one.
Yeah, and we've done another video on the whole benefits of the trust, and you can go and just deed it over.
Correct.
After the fact. And then our final option is community property, correct?
Yeah. So in Nevada, we're a community property state. Most states aren't. So
okay.
We're one of 9 jurisdictions nationwide that has community property laws. That means you can hold title between a spouse as community property. So it's only between spouses, first of all.
Okay.
So if you're not married,
so no businesses, you're dating someone and dating someone?
Yeah, it can't be
okay.
property unless you're legally married to that person.
Okay.
So that's where it's limited. But if you are married and you're going to take title to a home and you don't have a trust to put it in, community property has to also say with rights of survivorship. Very important wording. If it doesn't say that afterward, it's not going to work the way it's intended to.
Oh, okay.
So community property with rights of survivorship means that you own it as community property with your spouse. But if one spouse dies, the interest of the deceased spouse will transfer automatic to the surviving spouse.
Kind of like the joint.
Kind of like joint tenancy, but for married people.
Okay.
And in the end, the main advantage is really, it's for income tax purposes.
Oh, okay.
Not to get too far into that, but when you own things as community property and the spouse dies, the value of your property gets adjusted as of the fair market value as of the date of a spouse's death. When one spouse dies and when the second spouse dies. But with the joint tenancy, it's a little bit different. So for married people, I encourage them to take title in that way if they don't have a trust in place.
Gotcha.
Versus a traditional joint tenancy. But in large part, the object is the same. Let it transfer to the surviving owner, to the surviving spouse without going to probate.
But it has its benefits, and if Nevada allows it, one of the few that do, might as well take advantage of the benefits that they allow. So, obviously, the 3 major ways to take title are
tenancy in common.
Yep.
Joint tenancy and community property.
Community property. And you're going to see those on the document. They will make you check a box and initial. So either talk to your real estate professional, who will probably refer you to an attorney or an accountant that can tell you the best options for your situation, or do some research on your own before you get to that table, so you're just not taking the advice of a notary.
Yeah, it's hard to get in a situation you don't know what it means, and you have to put pen to paper, and that's where mistakes are made. That's where people like me find out when someone dies. We got to do a lot more work than we otherwise have had to do because they didn't know or have someone to advise them what to do.
Yeah. Save do some research up front, save you a lot of money and headache in the end.
Yeah, for sure.
Awesome. Well, thank you so much. If you have any questions about estate planning, Taylor's your guy, and we appreciate you watching this video.
Appreciate it, Beau.
Thank you for watching my video. Don't forget to like, subscribe, and share.